Hi, thank you guys for actually heading down to our campus. Today will actually be towards the seminar on intellectual property. I believe that everybody are here because have an interest in terms of what intellectual property is all about and how you're able to make use of it. All right, so let's get started. We're here at Training Vision. All right, thank you so much for coming down again. Building a life of significance. Right, first of all, I would like to introduce myself. My name is Xiao Yun. You can call me XY for short. All right. Yeah. All right. So actually, I'm a passionate, advocate of lifelong learning. I've been here, for up to 2 years now. Right, more than 2 years, and this is more than 50% of my working experience right now, lah. All right. I've graduated with a postgraduate diploma with Boston University as well as RMIT University. All right, and it's also on supply chain as well. All right. So moving on, this is actually our school. So our vision is actually to be the leader in human organizational growth. And for the mission-wise, it's actually to maximize human potential. All right, through this applied knowledge, best practices, and innovative mindset. All right, so moving on, these are all the values that we do hold. All right, so being spiritually driven, passionate, innovative, responsive, individual growth, as well as teamwork. So why Training Vision? I believe you guys are all headed here because you want to know more about Training Vision as well as intellectual property. So just to give you a rough idea, we have actually been here in this market for over 30 years. All right, this is actually our 30th year, right, in terms of education. Right, we do have SSG. We are actually appointed by SSG as an ATO, authorized training organization, right, for WSQ courses and diploma programs. Right, we also do have EduTrust 4 years for Higher Education Institute. We have trained over 120,000 students right now. All right, and the number is still growing. Right, over 700 corporate, as well as 5 training campuses. All right, across Singapore. All right, island-wide. So over here is our Cathay campus. All right, we do have campus at Jurong East, Hougang, Tampines. All right, so these are all the campuses that you are able to attend the programs for our site. All right, we have over 100 certified academics. So academics are something that might be a bit foreign to you guys, but just to let you know, it actually means practical and academic merged together. So not only would they be always trying to convey you in theory components, but also on practical side as well. All right, and then lastly, we do have 9 university partners. All right, Institute for Education. So these are the 9 partners that we do have. Of course, RHT Academy is one of the one that we are focusing on today. All right, we actually do a bit of in terms of law, intellectual property law. All right, we do have other institutes like Boston University, all right, as well as Digital Marketing Institute and EC Council. All of them are all the leading players, in terms of their respective field. All right. So moving on, these are all the brands that do trust TBI. They have actually attended our training, and then actually, make their employees grow even better through our education. All right, so as you can see, some of the big companies such as CWT talking about those, Ministry of Defense even. Right, so these are the things that you'll be able to expect. All right, so as mentioned, these are the 5 TBI campus over here at our Cathay City Commune campus.
You turned toward me and looked so weak. I'd never seen you with such tired eyes. And everything we said we'd be, we just traded for a suit coat and a tie. Feel just like you were young. Standing underneath the rosy tree, you can see where the ocean meets the sky. Under our clothes, a fire grows. We are ready for this life of running wild. Underneath the rosy tree, I will see you where the ocean meets the sky. Under your door, the fire grows. You are ready for a different kind of life. Silent boy, the wind is cold. You must return to the wild. Silent boy, the wind is cold. You must return to the wild.
Right. Thank you for your time. So this is actually our 3-minute, like video in terms of what you are able to expect upon completion of our programs here. This is actually our 2019 cohort who actually finished their diploma and even to the degree programs. All right. So moving on, we actually sorry. I'd like to introduce you guys to our guest speaker over here, right here. All right, Mr. Rizwi. All right, he has been here, all right, for over 20 years in terms of intellectual property as well as technology practices. All right, representative and partner of RHG Law Asia. Right, and today you'll actually be here to talk more about intellectual property. All right, Mr. Rizwi, please. And another round for our guest, Mr. Rizwi here. Thank you.
Okay, thank you, XY. Okay, today I'm actually going to talk about actually the primer on intellectual property, right? Nothing beats. Okay, so covering the types of IP and then of course the value of IP. Now, nothing beats a showing by example. I think if I talk all theory, you guys will get bored. So let me just give you first a rundown. These are some of the main types of IP that are around, okay? Trademarks, patents, copyright, registered designs, geographical indications, and plant varieties. Okay, before that, let me ask you, what do you think IP covers? Or why is that IP? Anybody can try a guess? IP captures creativity. It captures knowledge, captures your imagination, and you puts it in tangible format. Okay, I said nothing illustrates better than an example. The simple phone or iPhone here. Inside here, there are many examples of IP. that I can illustrate. Now, the phone itself, this is a form of a registered design. Okay, because there needed to be a design originally in order to know how to put the phone together. Okay, patent. Patent covers some of the inner functioning of within the phone, how it works, the technology, and some of it, to the extent that it's patentable, is protected by a patent. Copyright. If you have apps, if you have icons, and the icons contain material inside, those are copyrighted material. And finally, trademarks. Okay, I guess this is the best way to show this. Can you see this? Can you see this? That's the Apple brand. That's a trademark. Okay, so everything is inside here. Now, two other types of IP just to complete the picture. Geographical indications. How many of you like to drink? Drink? Champagne? Bordeaux? Okay, those are geographical indications. Champagne is a region in France, but it is also a brand of, shall we say, very nice alcohol, which I've never had the pleasure of drinking. Okay, so champagne is an example of geographical indication. Just like wine. Do you guys know Bordeaux wine? Same thing. Bordeaux is a name of a city and a region in France, but it is also the name of a wine. And that is an example of a geographical indication. I mean, I'm only citing the European example. There are many examples in Asia. India, there are quite a lot of examples of geographical indications. Okay, this is an example. Plant variety. Those of you who are inclined to play around with your garden, who like to create new forms of flowers, Vanda is Joachim. I think this is the only one that I know. This is an example where you can actually create a new plant variety and you can actually protect it. Now, as I said, these are all almost the complete picture. These two are very rarely used, right? And the most common ones are the top four, but just to give you a complete picture. Okay, now you can imagine there are many, many examples that actually you can apply nowadays. In fact, for those of you who are prefer to have designs on your face mask, right? Those of you who have designs on your face mask, I think this is one example. Tartan, right? The tartan design, right? Okay, so the face mask itself is not an IP. Design on the face mask itself, to the extent that it is a creative piece of work, that's an IP. Most likely copyrighted material as an artistic work. Okay, so just to illustrate the different types of IP. Okay, to give a basic primer. Now, of course, if you open your mind wide enough, you can see that a piece of work can have different types of IP depending on how you look at it. Okay, artistic work, right? To the extent that it becomes a logo, it can become a brand. This is an artistic piece of work, but it's also a brand. So it's copyrighted, protected as an artistic piece of work. It is also a trademark to denote that this is a product of Apple. 3D designs can qualify as registered designs, okay, in certain circumstances, but it also can combine. So the point I'm trying to make is that even if you have creativity, even if you want to say, okay, how am I going to protect it? You need to keep your mind open, right? There are many possibilities. right? Knows no bounds, knows no limits. As long as you keep your mind open and you are aware of the different possibilities. Okay. Those of you who are lucky enough to be in my class, I will try to explain in greater detail with better examples how all of this can be done now. Okay. Okay. Now, those were the registered IP. These are some of the things which maybe, if you want to go a little deeper, right? Dig a little deeper, understand better. Okay. Goodwill and unregistered words. Goodwill is your reputation, right? Sometimes you know something by reputation, but they actually have no brand, they have no trademark, they have no registration, but you know them by their reputation. That's their goodwill. Okay. You got also unconventional IP. Do you believe that there is copyright protection in a perfume? Do you believe? Anybody? Anybody don't believe? Sorry. Okay. Anybody don't believe? You may ask yourself, how does copyright exist in a perfume?
Certain formulas created by someone is his own, like IP, like intellectual property. He invented the formula of certain flavor or certain
Formula.
Yes.
Correct. Yeah. That will be the 2D version. The perfume will be the 3D version, just like a recipe.
Yes.
Okay. So a perfume also is capable of IP protection, the unconventional IP. So if you open your mind, like nowadays, when you talk about new things.
Cosmetic, all this kind of shampoo, would that come under?
Okay, it's okay. Every new thing has IP, but is it original? Is it original? You see, or are you copying from someone else? So that is another distinguishing factor. To qualify, you need to consider like whatever you're creating is something completely new, which is not copied from anyone else. Okay, so perfume, unique jingles. You all know what are jingles? Right, so jingles can be, okay, jingles are usually musical works, so copyright. But do you again believe that you can have a jingle that is protectable as a trademark? Yes? Right. Just like one more thing, I think the shape of the Coca-Cola bottle, the traditional Coca-Cola bottle. Any of you who are old enough will know and appreciate Coca-Cola used to come in a very unique shaped bottle. That is also protectable as a trademark. Okay, and then of course, derivative works. Derivative works, basically, if you imagine a piece of work is a parent, derivative works will be like the children or grandchildren. Okay, sometimes you can have version A, just like, okay, this is not a very good example, but yeah, I think this is a 12, I think this is an iPhone 12. So can you imagine iPhone 1, 2, 3, 4, and so on? Okay, so this could be, right, to a certain extent, a derivative work. Okay, maybe this is not a good example. Derivative works will be, what is the best example I can give you? Cartoon. No, sorry, a computer game. Computer game is the best example of a derivative work, where you create something, and then you have version 2, version 3, version 4. Okay, but it's the same thing, but there's an extension, a modification, or an adaptation. Okay, so these are just some examples of other types of IP. Now, of course, What's the point of creating IP, recognizing IP, acknowledging and recognize and sort of enforcing it without commercialization, without making money out of it? Okay, so identifying it, managing it, commercialization. Commercialization, the point of some of the IP. Those of you who recently read about what is it? That $69 million NFT, non-fungible token, a piece of art by Beeples, right? Now that's a piece of art. Okay, but that's the point. You make something of value, the consumer or the customer values it, gives it a value. So that's the point of IP. Okay, in case you needed motivation, but otherwise, this is one reason why people, this is one reason why companies, commercial organizations have a great interest in creating, maintaining, and enforcing their IP. Okay. Now, let's see here. Okay, so I'll come to the end of my little discussion. Now, is there anything that you guys want to ask? Anything at all? Yes.
So can I check this kind of trademark, right? Is there something like time frame where time frame that's abandoned, other people can pick up to use?
Whoa, abandon and take over. Okay. That's a very interesting question because it really depends on the reputation that you enjoy with your customers. There are people who actually want to take over an existing brand and then rebrand it. The clever thing to do will be to buy over all the rights from the existing owner. You buy over all the rights from the existing owner so that there is no problem with taking over, right? If you're talking about something which other people don't want, they throw away already, or you think they've thrown it away, and then you want to take over, without checking, without verifying, you just assume that this is safe, then it can be done, but it's not safe. It's not 100% safe that the owner, the current owner or the previous owner who is thinking of abandoning, or you think that he's abandoning it, will not come after you. You know what I'm trying to say? So it's a gamble, if you like. The safest thing to do is to make sure, right? You'll be surprised. Some people, they behave as though they abandoned something. Then when you come and take over, suddenly before you know it, you get a warning letter. Because they say, we never really officially abandoned it. We never had any, public notice or whatever, or we never said that we will give it to anyone. You see? Then you say, oh, we still have customers, old customers who recognize our brand. Then what are you going to do, you see? Do you have the energy, do you have the stamina to go and fight with people?
Basically, can I just build on that very question? Now, I'm just talking about, let's say, a particular process, an IP-related process. Correct me if I'm wrong, you probably will correct me because I'm not trained in legal aspects, but I was given an impression for any process, it has like a duration of, let's say, 5 to 10 years, after which anybody else can use the same process, but not with the same brand name. That means just a generic process, maybe a particular way of manufacturing.
Okay, you're talking about patents.
Yes,
patents
exactly.
and okay, so to be very clear, maybe go back to this. Now, okay, there's a reason why I segregated this from the other group. Okay, these are, right, to a large extent, these are all unregistered. Okay, whereas these are all registered. Okay, so what Adrian is talking about is actually patents, right? Registered patents. Patents has a validity period of, anybody knows?
5 years?
20 years.
20. Okay.
20 years, okay? Trademarks is 10 years, but it is extendable indefinitely. Registered design is also 20 years. Okay, you are right in the sense that the moment the registration expires, basically it goes to the public domain.
Yeah, that's
Only problem is if the patent is actually valuable enough, right? If I get a first patent and it's valuable, I'll get a second, third, or fourth patent. Then I will just extend it. But I won't be able to get the same technology. I will just maybe protect the enhancements, adaptations, or the improvements. Okay. Copyright is registered in certain countries, not in Singapore. Okay. Now, life of the author plus 75 years. Okay, so if you're talking about books, you're talking about musical works, you're talking about artistic works, that's roughly the time frame. But okay, this one there are many different rules, so don't quote me on this. I need to go and verify, but there's a certain time frame to this, which is much longer than the trademarks. Much longer than patents or registered designs. Okay.
So this is something which is very current, which we are all interested in. Count on me. Does that come under copyright or what?
Well, count on me. Okay, that one is a little bit of a. I think that is a bit of a evidence problem. Okay, because if I understand the facts correctly, the gentleman from the composer from India, he claims that he wrote it first, but he's got no proof that he wrote it first. And then it's like what, 1983 and 1986, something like that. There's a 3-year difference.
Yeah.
So my first question, if I were advising, was why so long? Why do you take so long before you actually claim ownership? You see, I mean, 1986 is like 35 years already. It's probably older than some of you. So, why take so long to claim ownership? Especially it's been playing so often here for so many years. Right? So to me, that is already
questionable.
Red flag. It's the first red flag. Then when you ask, usually when you say you're the owner, you need to prove ownership. Okay, let me ask you, how do you think somebody proves that they own an IP? I probably won't cover this in the course, but this is too esoteric really. But how do you think you prove that you own IP?
So that registration numbers.
No, registration is when you file the application, right? But that's a good point. Registration is prima facie proof that you actually own it, because it is a certificate of title of the asset. However, it is also prone to challenge, especially if you did it in bad faith. You do it dishonestly, right? Then it is prone to challenge. There are many provisions now. Okay, but how do you think somebody proves that they own IP? How?
Written documents.
I know, but see, date is the first most important. When it was created. So if I have do a little design and artwork and all that, and I want to show that I'm the original creator. I created this in 2021. So traditionally, what people used to do was they will send a letter to themselves using the post, and the postmark on the envelope will be proof that this was done on that date. Okay, so Of course, there are other things like witnesses, transcripts, blueprints, work in progress, those kind of things. Witnesses, I think, is quite important because if some things are not in writing, then the only other good evidence will be witnesses. Okay. Trademarks and copyright. The other thing to know is that if you commission a third party to design something for you, right? What must you do? What must you do? You must make sure that the designer that you commission agrees to give you the IP. So it's your idea, you draw for me, draw finish, you agree in writing that the IP belongs to me. Okay?
He just execute the idea. The designer just execute.
Yes, he will implement your thoughts, your thoughts and your dreams or whatever. You tell him, okay, then make sure he confirms in writing that it belongs to him. Again, all of this is evidence. Okay? Patents, the interesting thing about patents is that you have inventors. Sometimes you have co-inventors. Now, co-inventors brings about it a different story. Now, if all of them are friends, all of them are colleagues, shouldn't be a big problem. If you have inventor who is a independent contractor, somebody you just a consultant, right? Someone you just bring in to help you to invent this. Then after that, you pay him a sum of money and tell him, okay, thank you, goodbye. He's still an inventor, right? So when you file a patent, do you think he should be named as an inventor or not?
I don't think so. I think, whoever is the originator.
No, inventor, yes.
Must, is it?
Yeah, no, okay. By right should be, unless he says don't need.
Oh.
So by right should. Well, okay, let's put it this way. There are provisions to allow a party who can prove that he's an inventor to be named as an inventor. Of course, being an inventor and owning the patent are two different things. Right. You probably have no rights to the commercialization, but your name is there. Okay, I can tell you this funny story. When years ago, we were doing a trademark application. Then I asked them, okay, who designed this trademark? Say, the owner's son's ex-girlfriend. So I said, okay, fine, sure, no problem. I said, okay, so it's not someone who readily agreed to transfer. I said, okay, then why not just ask her to transfer over, confirm that she's surrendering the rights to you, no problem. She said, sure, shouldn't be a problem we'll deal with it. You see, no problem. A few weeks later, I get a call. Said, actually, a problem. I said, why? She's demanding money. I said, what do you mean by she's demanding money? She said, because the son broke up with her. Then, so from a so-called friendly relationship, creating this IP, right? It becomes a, arm's length transaction. Everything is commercial. Since you break my heart, it's going to cost you $9,000, something like that. So I said, okay. Then I said, then you need something in writing ready. So she agreed to a sum of money, in return for which she signed off, and she said, I agree that this particular designer, which I didn't know how many years ago, belongs to the party who applied to register the trademark. Okay. Geographical indications, some of the stories, actually, I gave you some very easy examples, but some of the stories actually which give problems are more to do with people who want to claim the geographical indication but cannot get it. I think the recent dispute was somebody wanted to claim rights to the tartan pattern. Tartan pattern, you all know tartan? Scottish, the Scottish men wear skirts, right? Kilts, kilts. And then the kilts are a certain pattern, red, dark green, and then if you know Burberry, there's light brown and red stripes and all that, right? So tartan is something like that, but it's all dark green and whatever. Okay, so some people wanted to claim that as a geographical indication. So ran into a lot of problems because historically there is actually no real justification. So there's a big fight over it. Okay.
Would little red dot qualify
As what?
as a
Geographical indication.
No lah, it's not. Okay. Yeah, Champagne, Bordeaux, okay, Parma ham. Have you heard of Parma ham?
Yeah.
Parma is a city in Italy. So Parma is also a what do you call it? Geographical indication. So it's got to have some geographical connection to it. As I said, like in India, there are many examples. Just nothing on the top of my head. Okay, registered design. Maybe a few interesting things here now. What do you think can qualify as a registered design if you open your mind to it? Would you believe me if I told you a toilet seat cover can qualify as a registered design if it's creative enough? Okay, the typical examples will be your watches, jewelry, right? Watches, jewelry. I have seen parts of a car we used to do for who was it? Proton Saga, right? They registered the design in Singapore. They will cover everything. Okay, the side mirror, the body of the car, the dashboard, everything they will cover. Okay, that will qualify as registered design. Okay.
Actually, Mr. Riz, we're just checking out for geographical indication, like for example, Katong Laksa, Old Chun Park, Char Kway Teow. Does this, have this kind of trademark or what?
Katong Laksa, the problem with Katong Laksa or even, what do you say, Katong Laksa and Old Chun Park?
The Char Kway Teow, this kind. Does that work?
Hill Street Kway
I
Teow.
think
Yeah, there's a lot,
geographical indications in 2019. I think we have a new agency that covers food and beverages. That's where it comes about that there are some particular items belong to a country, and people from another country can actually reproduce the same qualities, but they cannot claim to be from that country. Kind of thing.
Okay, but
there was a new thing that there was a new rule given in 2019.
No, they changed the law recently on this also.
So that's where geographical, as to things like Katong Laksa and so on, these are very confined to local.
Yeah.
It's more perhaps with trademark patents or
Sorry, what? Trademark?
something like.
No. Sorry. So
this is more of
this is a very
nature.
Yeah, this is a very high level one. It's not the
Okay, not the in local.
It's not like Sembawang or
Okay.
But then
Changi.
that raised me a question: what happens if there are two persons claiming to this, and each of them has registered in different administration?
You mean like what? One in China, one in Europe.
Take for instance, like the simple thing like count on me Singapore. Okay, you register in Singapore. Of course, Singapore will recognize it. But that guy, he could have registered in India.
Right, but he didn't.
No, assuming that he has.
If he had.
How does this IP come about internationally?
Okay, that's a good question, because if he had registered in India and he could prove that he registered in 83, 84, that's a big difference to the story already, because that will lend weight to his claim that he's the original owner. Okay.
Yeah.
But
So
okay, maybe I give you one example.
so I can see that this whole idea is more of of a business concern, unlike plagiarism and so on. It's more about business because you use it to gain business value. Any business value that you gain are lost, right? There is no such thing as two different companies sharing the same value. Whatever that you win is my loss. Whatever that I win is your loss, and that's where it comes from. But if it's about who comes first, it's a matter of proving if that guy in India who claims that he has done it, and he happens to be able to produce a piece of silver paper that people is able to examine and say, hey, I think this comes from even the 1940s. Yeah.
Sure, why not? Okay, maybe to help you illustrate. Help everyone illustrate. Yeah. Have you heard of crocodile brand?
Yeah, and Lacoste.
And Lacoste.
Yeah, exactly.
Okay, crocodile and Lacoste. The difference is one crocodile looks left, one crocodile looks right. Okay, one is one is European, and one is Asian. Okay, so in Europe, all the action that is taken, guess who prevail?
European.
Okay. In Asia, when you take legal action, guess who prevail? Crocodile. See. So the interesting part was we were all looking was in Middle East, right, where no one has a real hold on it. Who is the one that prevails? Okay. So Middle East was very interesting also. We didn't really get a clear picture. Which shall we say? Because
but the point is about prevail because we know the way that the whole world works. It's more than just evidence and so on. There's a lot of relation, a lot of good deal, all this jumbled in together to make the so-called judgment, final judgment. Well, I do not know.
Oh, this is getting interesting.
Yeah. This is
no. This is actually correct. This is correct. That's why I
can say that this is a blackboard. This is a blackboard. I see black color. Yeah. We can argue the whole day, no end.
No, actually, what you say is true, but I don't think this is the forum to discuss this, sorry, yes.
I share with the gentleman that he says correct. Is it for young entrepreneur or technopreneur? They have come up with something new. They want to patent or trademark or copyrights. So when we do any IP registration, we always look in the local context in Singapore.
Right.
But in somewhere when you have registered in Singapore, does you need to go and Google and search the whole Google to find anywhere in other country has some similarities before we?
Well, it depends on where you want to operate in the future. We always recommend that if you want to operate regionally, right, the best thing to do is to protect everything regionally. Regionally, I mean, if you want to do that, if you want to do internationally, China, US, Europe, then it's up to you also, see. Number one, everything costs money. The more countries you protect, the more money it costs. Number two, if your product is good, if your brand is well known and popular, it is inevitable that there will be people who want to copy you. Okay. Number three, you better hope that the people who are helping you didn't copy from anyone else. Otherwise, you also face problems also. Okay. So all of these things, these are just some of the practical realities, okay? When it comes to, like yes, everyone says, there's nothing in black and white. Sometimes it's a gray area, okay? That is so true, okay? Especially in areas like this. But if you really want to ensure as wide a protection as possible, you do your homework, cover the region, cover globally wherever you are interested in. Okay, but you bear in mind that everything costs money. And sometimes it may be worth, or rather it may not be worth, shall we say, spending too much money, when in fact you have other practical solutions, right? Working out a deal with someone, that kind of thing. Okay, which brings to a point now, maybe to emphasize. IP protection, IP registration is limited by geography. Okay, you want to protect in Singapore, Malaysia, Thailand, Vietnam, Indonesia, Philippines, all that. You need to protect in each country. You can't just protect in Singapore alone and then expect it to be, recognized elsewhere. Good news is, for the longest time, many international associations have sprung up to assist people in protecting trademarks, patents, registered designs at an international level. Single application file in Singapore can cover several countries. Okay, it is possible. So there are procedures available also.
So this cover only marks, logo, or visible items. Does it cover services?
Oh, sorry, what do you mean? Because you see, a brand, okay, maybe I illustrate this. Okay, a brand can be associated with a product or a service. Good example of a service will be restaurant. The restaurant is not a product by itself. It's a service. It's a restaurant service. You serve food and beverage. You get a dining experience. What have you? Those are services associated with a trademark. You can protect that under a trademark as well. Okay. Sorry, if I
Yeah, sure.
overrun.
No. I think it's fine.
It's
I
fine,
think it's all right. It's all good. Maybe you can share, is there any questions online as well?
Yeah.
There's no questions online so far. Yeah, I think we have some reserved questions, right?
Yeah, of course. Actually, just like to check, right? In terms of just a personal question, right? Because you talk about the duration wise of the trademarks and everything. What if the company actually goes bankrupt? Like, do they lose the copyright immediately, or is it like still based on the duration?
Okay, this is a question I also don't know how to answer, because the registries take a very different approach. We have encountered before, similar to what the gentleman was talking about taking over. So we have encountered before where the trademark was blocking our client's application to register a new brand. It was identical.
So how about a family business? Does it mean that belongs to every family member?
Family business is a different story, because that one is, that one is everything boils down to evidence. That's the problem. Everything boils down to evidence. Okay, but like I was saying, so there was a brand which was owned by someone, and our client wanted to register the same thing, right? Blocked by them. Then we found out that the current owner was already bankrupted in Australia.
Yeah.
Wound up already. Died, the company died already, you see. So we told IPOS, I said, hey, these people are dead already, what? So, just, push it off, and then our client can register lah.
Yeah.
No, cannot. So we said, okay, fine. We found proof, the ACRA search, equivalent of ACRA in Australia, to show that it's dead. Submit.
Why?
Because they claim that the mark is still alive, right? What if somebody else has bought over it? So it was a real problem then. So we say, okay, fine, but we cannot prove that someone's going to buy over the mark. What? Then how do you show that the new brand can sort of like supersede because the old owner is dead, a company wound out already?
Yeah.
No answer.
Oh.
So because it took so long, our client gave up. They said, forget it. We will try another way. But that's the reality of the situation, you see. So to your answer, if somebody dies, I can't really tell you, because this is the position they take. Okay.
So they can make a will to inherited to survivor family members for the trademark.
Yes, I believe so. There's an asset that can be transferred. Yes.
All right. And do you think that, based on your experience, right, do you think that every company should, at least, do their trademarks, do all the intellectual property protection first before actually going on? Or is it like a halfway thing,
Okay, this one, I think the best thing to tell you is it really depends. Everybody, we tell them go and register, right? Some people will say, okay, we cannot afford to register everything. That's the one. Some people will say, okay, We will only register if this brand becomes popular or commercially attractive. So you cannot say also. So they will say that, as you say, wait and see. Okay. Others will say, no, we want to register first before we go to market. Okay. So it really depends. Yes.
What if someone invites me to the restaurant, then I see the recipe, I copy, then I register then before.
What you copy? But okay.
He doesn't even bother to do his own copyright.
Oh, no. Copyright is not registered. So it's already, copyright already exists in the recipe already.
Oh.
So once you copy, when you open your new restaurant, you put your menu around there, they come and see, right? Then you got a problem. Recipe is not registrable. In fact, the other thought, right, which is passing off. If you have a certain or you see a certain type of recipe, maybe from a specific province in China or a certain state in India or whatever, you see, and then you happen to like that kind of cooking, and then you copy and all that kind of thing. But you don't copy just the type of cooking. You copy all the specific recipe, right? You might have a problem also, you see. Same thing is don't copy everything. You just say, okay, this is Southern Indian cooking, for example. Then you just have something generic, nothing specific, nothing identical, you see. That's the safest thing to do. Actually, why am I teaching them like this? Shouldn't be teaching people what to do and what not to do. It's not a very...
Rizwi in the position, for this kind of thing, he normally charges $300 an hour.
No, not $300 an hour.
No?
More than that.
More than that, okay. So, you guys are really blessed that you can ask questions.
I would rather put the owner of responsibility on the various administration. Each of them must have some kind of standard as administrations, whether when you come to me to patent anything, being the administration, I should have a wider knowledge than you. And I know that, hey, this guy is asking to patent something that is going to create a problem. So a lot of duty of care lies with the administrations. Unless it comes about, I don't care. Count on me, Singapore.
But count on me, Singapore.
I will still patent it in my country. I don't worry about Singapore. Because, frankly speaking, we may be singing here all the time. In many other countries, they may not even have heard about us. And, yeah, it's we who think that our song is so nice, so popular, but it may not be heard in them. And somehow, some way, some guys just come.
Okay.
Wise men can think alike, no?
Actually, that is, I don't know how to tell you this because first thing is, if he really owns it, he should got it registered. Once you have a registration, there is no dispute really. Especially date of registration, that one is very important.
It's been business savvy, business intelligent, business smart, but there are a lot of, which is why even the Apple with the logo, I believe that a few years back, one student was saying, hey, I was actually drawing there, but somehow being a student, I don't know all these things about IP, to me, I'm happy I draw it.
It may surprise you, but Apple have actually lost cases before where they have accused people of patent infringement, shall we say. Or, sorry, they want to invalidate other people's patents on the basis that it is actually invalid or whatever and all that, with a view towards buying out the company. And they have lost because this was in the States. They found that the patent of this small company was actually valid and robust enough to stand up to scrutiny. And because of that, they were able to say that Apple is actually bullying them. They are having cases like that also. So it's, if your technology, if your creativity is genuine and you really did it first and you actually take steps to actually protect it properly, right? You shouldn't really be that worried. It's only if you have a weak foundation, or like what this gentleman is saying, there is a dispute as to who actually owns the IP rights. Then yes, that's what I call it, foundation for messiness lah, as you put it, and all the problems that arise. You say this, I say that, nobody can, and then depends on who's bigger lah. In that sense, yes. Then whoever's bigger will probably prevail.
That reminds me of, I think, Samsung and IBM. On the European side, the West side, IBM win. On the Eastern side, Samsung win. Different court, different verdicts.
No, I think you're talking about tablets. Tablets is
Something like that.
Samsung and Apple. Samsung and Apple.
Yeah, many years ago. So
they sue everywhere. What? Germany, Holland, Australia, UK, US, Europe, everywhere they sue.
Yeah, but at the end of the day, this is all about business. Business looking upon this IP as an asset, business assets across, can be tangible, can be intangible, in all the six senses. It comes about with whoever people will fight about it only when they think that, hey, some value for me has not been recognized. I've not been paid.
Yes.
So even if someone were I have already patented this Apple logo as my company trademark or whatever, and if this student come along, and I think maybe it's okay, it's almost the same thing like our info. Just put a small little mark that this was invented by this student.
Yeah.
Okay? Yeah. You are recognized. Regularism, no more. You are recognized, and it's okay. I just put it there, and that student will most probably be happy that he's recognized.
Sir, I think it was very interesting, your questions, but we also need to acknowledge that, I want to just say this here, I want to stand corrected. Earlier, I misquoted when I said that, the charges are $300 an hour. I'll just correct this, actually $900 an hour. So that's not the issue. The issue is that...
Hey, don't.
The issue is that there are other, there are many questions that, we discussed quite a few things here. But I think the whole idea of this particular, I would say expose, for lack of a better word, is to let you guys know that this particular area is a very interesting area. And this is just one of the modules in our whole program, which later we will probably share about. So I'm not supposed to talk, but I thought I'd just come in and just, interrupt there. I'll give it back to, X, Y, and F. Please carry on.
Thank you, Adrian. Yeah, so actually I'll just be... Yeah, correct. Yeah, so anyways, as I previously mentioned, this will be really interesting. It's just one of the modules for intellectual property, and Mr. Rizvi is actually one of our trainers as well. We'll be talking on this sector. So these are the contact details. But of course, be moving forward. So first of all, because of our partnership with IHT Academy, so just a brief introduction. All right, so it's actually a subsidiary of IHT People. All right, and these two logos that you're able to see is actually highly related. Actually, Law Asia, which is basically partner for Mr. Rizvi, right? And I would just say that all of our trainers here are all pretty seasoned lawyers, all right? So they do have tons of experience to share, like Mr. Rizvi, right? In terms of intellectual property, even criminal law. These are just some of the modules, all right? So today we'll just be talking slightly about Diploma in Paralegal Studies. All right, so moving on. Right, so for this program, I'll just let you know it's our part-time course, right, and takes roughly around 8 months to complete, all right. I would say that in terms of our target audience, you can see that those who like to function as a qualified paralegal, I would say that, in terms of age group wise, there isn't any limits to it. All right, for people who are looking for a new career, or maybe even say career switches, definitely welcome to do so. All right, should you be wanting to pursue a career inside the legal environment. All right, so this is the course objectives, right? Basically to understand the legal system better, and then how you're able to, assist seasoned lawyers like Mr. Rizwan to assist him in the cases lah. All right. So this will be the module overview. As mentioned, intellectual property is actually the last module, total of 18 hours. All right, as you can see, there's actually quite a lot of hours. Right, so that's the reason why it actually takes up about 8 months. All right, so intellectual property, criminal law, family law, company and partnership, these are all the things that we covered. Right, of course, today what we mentioned about just intellectual property, just one module. Yes?
No, Cop Side Practice, Mr. Chu Kok Liang. He's standing here.
Yeah.
Yeah.
Okay.
Yeah, of course. So, in terms of the trainers, why it's actually quite different, right? Reason why is actually everybody do specialize in a different topic, right? So this is the reason why, everybody is focused and, able to teach you much better with their own experience. All right. So, this is the, sorry. Where was I?
Okay.
All right. Yeah. Okay. So these are all the trainers. You can see Mr. Rizwan and Mr. Ko not here. Sorry, but there's actually a total of 7 trainers for these 9 modules. Some will be repeated, but these are basically our trainers. Right. So the key benefits. All right. So just to let you know, guys, that this will actually be 100% fully online program. Right. So which means will be via Zoom. All right, of course, do note that there won't be any requirements to buy any textbook or whatsoever in terms of law. So I would say this is actually quite cost efficient. All right, so all your trainers will actually be legal practitioners in terms of wealth of industry and practices. All right, and we do promote small cohort learning. So which means that each class will be roughly around this, maybe even slightly lesser than this size, but 1:25. All right, and the assessment will actually be carried out in this assignment, case study, group presentation, and slightly bit of a written exam. But of course, I would say the majority of the time it will be more towards case study and group presentation. All right, written exam not so much. Reason why is actually we do understand that in terms of adult learning, we do want to have more practices. Not really like more of theory kind, where there's a right and wrong answer. There's always room for debates, like just now, what's going on right now.
Actually, mine is actually all right or wrong.
Yeah, yours is right or wrong, but some of them is a bit different, talking about, like for example, the recent cases about those kind of negative news about rapes. There's always going to be defending side, even whether it's right or wrong. All right. So these are the costs for your investment. All right, this is basically the cost fees. All right, so total we can see is roughly around close to $9.4 thousand. All right, we understand that for learners, price might be an issue. So we are actually going to be breaking down this cost into 3 installments in total. All right, and if you do register with us by today, you are able to make a waiver of the $53.50 application fee. All right, but of course, do note that at this current point of time, you are able to utilize your skills future credits or whatsoever. All right, so this is basically the net fees, and if you do register with us, $53.50 is waived for today. All right. So moving on. Okay, this is the next available intake if you do wish to pursue a career in paralegal. All right, on the 24th of May. Right, the lessons would be during the evening. We understand that all of you guys most likely have a job, right? So we do not want to disrupt that. So that's the reason why we actually do it during the evenings. All right, every Monday and Thursday from 7 to 10 p.m. All right, so of course the lessons would start sharply, punctually, and then it will go on for the total of 8 months, every Monday and Thursday only. You won't be eating into any other days. All right, so as mentioned, it'll be via Zoom as well. All right, so if possible, if everybody is able to scan the feedback form, so they'll be able to know how to improve our processes as well. All right, of course, once you actually do up the QR code, all right, please do so now. Actually, thank you. All right. So once you guys have actually went through the whole feedback form, all right, we are able to so-called assist you better. I understand that some of you guys actually have more questions, whether it's on intellectual property law or whether it's on the whole diploma program as well. All right, so we do urge you guys to actually seek to your respective consultants. I believe that somebody actually contacted you guys lah. All right, before you actually head down over here. So you can actually approach your respective consultant and they will be able to assist you better in terms of the product or it was so-called the diploma. If you have any questions in terms of intellectual property, Mr. Ridwan will be here as well lah. All right. Yeah. Is there any questions from the...
There's a question regarding intellectual property.
Would you like to answer that?
Do you have time?
We have 5 more.
Yeah, Safia.
Okay, I'll show you. Take one question.
So it's from Priya. Is an assignment or transfer of rights enough evidence for ownership of IP? Like an inventor creates an invention while in employment. Will the employment contract give the employer the rights?
Oh,
Very specific.
this one is okay. I hate to tell her, but in most jurisdictions, employment is the default position is anything done in the course of employment belongs to employer. There is no, no need for an extra assignment as such, but usually people will put it in the contract of employment to be absolutely sure. Okay, so there's unless the employer says no need lah, but that's probably never going to happen now. Okay.
Understood.
Thank you.
Yeah, all right.
Okay.
So if there's no other question, after you guys have done the feedback, you can actually head down over to our pantry to have the refreshments. We do have some cakes and puffs available lah. Right. So we'll be holding you here for long. Thank you so much, guys, for your time. Right. Thank you. Please give us a round of applause.
Okay.
Yeah. Right, so just stay here for afterwards. If there's any queries, then afterwards can.
Can. No problem.